This is SJC-13025. Commonwealth v. Shaquille. Malcolm Brown.
Attorney Billowitz, please.
Good morning. May it please the court, Elizabeth Billowitz for the appellant Shaquille Malcolm Brown. I'll begin with the sufficiency of the evidence and the jury instructions and then move on to the grand jury indictment. At trial, there was insufficient evidence of Brown's identity as the shooter and a premeditated murder. To put it less dispassionately, we simply don't know enough about what happened here to incarcerate a man for the rest of his life. Without physical evidence, eyewitness, ID, or motive, this conviction can only rest on a chain of tenuous inferences and speculation that Mr. Brown was visibly plotting a murder in front of Rosario Market, that Mr. Brown was the man with the chipped tooth seen several minutes later, and that the man with the chipped tooth was the shooter. This string of inferences starts with the Rosario security video, and I realize the court may or may not have had an opportunity to view this yet. It's about a 13-minute compilation showing Mr. Brown and his former co-defendant in a parked car outside the market. I hope the court does get a chance to see it. Certainly, you will not see Mr. Brown plotting an execution and deciding to hunt down and execute the victim as the Commonwealth claimed in its closing argument. This is wildly speculative. It's not reasonable to infer premeditation or intent to kill from anything seen on this video, especially by somebody who has absolutely no connection to the victim. The Commonwealth asked the jury.
You have, though, the identification of Mr. Brown as the person in the video, right? You're not correlating.
Yes. Now, it is not disputed that he is seen on this video about 2 blocks away from the shooting and about 10 minutes beforehand. The Commonwealth asked the jury to infer this deadly plot from Mr. Brown's movements on the video. There are 2 problems with this. First of all, that is precisely the piling of inference upon inference that this court has forbidden. Second, that's not a reasonable interpretation of the video. The video doesn't show Mr. Brown furtively ducking down to avoid being seen. And this part is worth a careful watch. It's about 10 minutes in, and the timing and sequence are really important here. What you see is the victim exiting the store. Mr. Brown is at that time getting out from the passenger side of the car. The 2 men actually face in each other's direction for a number of seconds, while Mr. Brown is making no motion whatsoever to hide or duck away. The victim then turns to walk down Ashmont Street. Only then do you see Mr. Brown bending down. It's not clear why. At most, this is an ambiguous gesture and cannot bear the weight of these additional inferences leading to a first-degree murder conviction.
That's just one part of the chain, but then we have thereafter, we have that witness who is going, post-workout, who sees the, by inference, your client talking to the victim, gunshot, and then we have your client running away and no one else on the street.
Well, certainly I would not say that was our client running away. All we had here I
would hope not, but I think there's at least it's up to the jury to figure that one out, right?
The identification evidence was extremely tenuous. It was a description, not a positive ID. Yes, and the jury could have made the inference.
Right. I don't mean to throw you on your presentation because you're going to get to the ID. I assume, but please continue. I didn't want to interrupt.
No, certainly, and that is the most important inference that the jury was asked to make. I just want to make 2 brief points additionally about the video, because the Commonwealth does ask it to do an awful lot of heavy lifting here in terms of intent.
Well, let me ask you about that, because I think you brought out a really fair point that the plotting statements in the closing argument probably weren't supported by the evidence, because we don't know what was going on out in front of Rosario's Market. But on premeditation, we have the use of a firearm, someone shot right in the eye. Don't we usually say intent to kill and premeditation are pretty clear from that type of a murder, especially using a firearm?
There are some critical elements that are absent here. So you're asking whether it's fair to
Well,
infer premeditation from the manner of the killing.
yes.
Nobody saw this here. And critically, nobody saw a firearm either on the man with the chipped tooth, who was seen by the eyewitnesses, or on Mr. Brown, the person who was identified as Mr. Brown on the video. So this isn't a case where premeditation can be inferred by bringing a weapon. There was only a single shot here, so this isn't a case where you can infer from multiple blows that there was time in between blows or shots to have deliberated.
Assuming for the sake of argument, I know you don't concede it. Assuming for the sake of argument, chipped tooth is your client. If that's the case, the person had to have a firearm in his possession. If that's the case, the person certainly had to have a loaded firearm in his possession, and the person certainly had to point it at someone and shoot him in the eye. Certainly intent to kill, but why not premeditation?
Well, this is exactly the kind of stacking of inference upon inference. We don't know that the person that the witness saw either approaching the victim or leaving afterwards. We don't know that they had a gun. We don't know we simply don't know what happened. We didn't see anything other than a friendly conversation. We didn't see any kind of altercation. We don't know whether there was another gunman. The record was clear that anybody who was running in the opposite direction would not have been seen by either of those witnesses. It is equally fair to infer that the person running away with the chipped tooth, who had been seen in a friendly interaction moments before, was fleeing from the gunman, was running from the expected arrival of the police after a shot. This is just simply such a blank slate. And so the point is not so much that, whether one of these inferences could be made. It's that you need A to B to C to D to E in order to get to premeditated murder beyond a reasonable doubt. I want to be very clear that there was no positive ID here. The witnesses only gave a description. One of them gave a description with a little bit of specificity, pointing to the distinctive feature of the chipped tooth. Distinctive, I would say, by no means unique, particularly in this city neighborhood, mixed income neighborhood. The other descriptions had absolutely nothing distinctive. They didn't agree on the color of the clothing, otherwise completely generic, and could easily have described any number of young men in the neighborhood.
Did the height match your client? So we had an estimate. One person said 5'6" to 5'9", another person said 5'6" to 5'8". And I forgot from the record.
It's a pretty wide range. Mr. Harper, the main witness, his account of the man's height ranged from 5'6" to 5'10".
It's 3 inches. But how tall was your client? Was that in the record?
I don't recall if it was in the record. I believe he was somewhere in the range of 5'6" to 5'10", which was what, I would submit that probably describes, 80-90% of the male population. His skin tone wasn't described with any particular specificity. So really it all hinges on this detail of the chipped tooth. I want to go back to the video just very briefly because the overstatements here, I think, are really warrant a little bit of redress. And I was surprised when I first saw this video, after reading how the Commonwealth characterized it. I want to be clear, you will not see the video showing Mr. Brown peering into the store to make sure that the victim was alone. You'll see him approaching the store. He's looking around. It's not at all clear what he's looking at. And it's terribly speculative to say that he was confirming that the victim was going to be alone. If the victim entered the store alone, and left alone, what would the interior of the store show? Importantly, the video also doesn't show Mr. Brown following the victim. The car that he's in drives off 2 minutes later down a one-way street. It's the only way it could go. So even if this video evidence was as clear and incriminating as the Commonwealth says, we still have to connect the dots of, was Mr. Brown the man running from the scene? Was that the man who shot the victim? And again, we don't know. We didn't see. That is a big question as well. And did that man do so after a period of cool reflection? I want to very briefly address the firearm found in the closet. Mr. Brown's connection to that firearm was so attenuated that it really should not have been admissible in the murder case, more prejudicial than probative. Even if that ruling was an error, it does not add enough to the other evidence here to prove a premeditated murder beyond a reasonable doubt. Whether the jury could reasonably make one or even some of these inferences is not the question. It's whether this conviction can rest upon tenuous inference and speculation. And we urge the court to reverse the murder conviction for insufficient evidence. Moving on to the identification instructions. As Justice Daziano noted, the most critical inference that the jury was asked to draw here was that the man seen by Barnett Harper was Mr. Brown. And so it was of utmost importance that the jury be guided by accurate instruction on this point. The judge gave a modified eyewitness instruction pursuant to Franklin to address this unusual situation where the witness is making a description rather than a positive ID. There were several errors in the instruction that I address in my brief, but in the interest of time, I want to focus on the two most serious. First, the instruction repeatedly referred to an identification instead of a description. And this was incorrect because, of course, there was no positive ID. And it was the jury's job to make the identification or not based on this description. So repeatedly referring to an identification as a fait accompli was, at best, was prejudicially confusing to the jury. At worst, it usurped their fact-finding function. If the jury found that Mr. Harper was generally a credible witness, they could have understood this instruction to mean that he made a positive ID, and this obviously could not be a correct basis for their finding. For the jury to find that Mr. Brown was this person, they had to make that finding beyond a reasonable doubt. They were not told this. The judge refused to include the reasonable doubt provision that is featured in the model eyewitness ID instruction. The court said in Johnson that one of the primary purposes of an eyewitness ID instruction is to inform the jury of the Commonwealth's heavy burden of proof as to the accuracy of the identification. And
isn't that the inherent problem, counsel, that we have a model instruction that, I think you're right, is geared towards traditional, I looked at an array, I identified this person, and we have judges trying to modify that to meet descriptions of clothing or other unique characteristics, correct?
That's correct. And I believe that the instruction that was proposed by defense counsel would have done the job precisely. It replaced the term, removed every reference to the word identification. And of course, it included the model reasonable doubt provision that says, if you are not convinced beyond a reasonable doubt that the defendant is the person who committed the alleged crime, you must find the defendant not guilty. There is another problem with that omission that I want to lay out very clearly because I did not go into depth on this in my brief. The omission of the reasonable doubt provision here lowered the criminal standard of proof, because here the jury could only conclude that Mr. Brown was the man that Harper saw by means of an inference. But the jury was instructed that inferences only need to be reasonable. The identity inference had to be more than reasonable. It had to be beyond a reasonable doubt, but the jury was not told that. So for these reasons, the instruction also constituted reversible error. I'd like to move on to the grand jury indictment. The indictment was impaired by the reckless presentation of deceptive evidence in the form of over 100 pages of highly inflammatory DOC documents describing Mr. Brown's prior offenses and his violent acts in prison. The prosecutor apparently was seeking a connection between the two defendants who had both been incarcerated at the same place for a few months.
Mr. Can I ask you about the hearing? Did Judge Roach credit the prosecutor's explanation, albeit perhaps wrong on the code of the need to present this to the grand jury if subpoenaed, or did she not credit that explanation?
No. The motion judge condemned the Commonwealth's actions generally as the opposite of best practice.
Right, but did she make a finding that the prosecutor was acting, that she didn't believe the prosecutor's explanation, I guess?
She said that his conduct met the recklessness standard. She said, the record is notably silent as to whether the prosecutor himself ever reviewed the correction documents to make any responsible assessment of their probative value, and if so, why he chose to submit those records. I don't recall a finding specifically on his explanation that he thought he had to turn over everything. It was the record was not clear whether he himself ever reviewed the records. Either way, it's a problem.
Right, I'm just going to the good faith or bad faith of the mistake.
Well, I think all of it is required as recklessness. That's all that's required for an Odell Mayfield violation. And the judge was very clear that that standard was satisfied. The motion judge is correct on the first two elements of Mayfield, that the introduction of the documents were done in reckless disregard and for the intention of obtaining indictments. She was incorrect on the third, whether the evidence probably influenced the grand jury's decision to indict. She held that the records didn't make a difference because there was evidence from which the grand jury could have concluded that Brown was the shooter.
Right. Counsel, can I ask you a question? Does the fact that there was then a trial, does that correct any alleged irregularities to the grand jury?
It doesn't, and Mayfield is crystal clear on this, that even after a jury has reached another conclusion, that doesn't satisfy this court's obligation to review the integrity of the grand jury process.
Thanks.
So the records here depicted Mr. Brown as a violent criminal with propensity to commit a cold-blooded shooting. It's quite possible, given the weakness of the evidence here, that it distracted the jury and influenced an indictment. Whether probable cause is satisfied cannot be the be-all and end-all of this step of the analysis. Otherwise, every Odell violation would disappear if McCarthy was satisfied.
What was the factual finding? I'm sorry, what was the factual finding the judge reached that it was done to secure an indictment?
Simply that I don't think there was any specific detail on that finding. I mean, I'm not sure what other purpose there could have been to submit this. This wasn't a situation where the prosecutor was simply answering a question that one of the grand jurors asked. I think the only other scenario in which this court has held that second Mayfield element wasn't met was where the evidence at issue was exculpatory. So I think it is beyond question that this evidence was introduced recklessly to secure an indictment. And given the weakness of the evidence of guilt, given that the bad acts evidence here was so voluminous, so prejudicial, it was introduced affirmatively and gratuitously. It was not remedied by.
That's why I asked you initially about the factual findings regarding the Code, case, because if it was done under a mistaken belief that it had to be done so it wasn't an abuse of grand jury process, it wouldn't have been done to secure an indictment. So that's why I was asking about factual findings.
I don't believe she specifically addressed that. I'll certainly review it and update the court by letter. I believe that I'm not even sure that explanation was offered at the time. I believe the first time I came across it may have been in
maybe it's not.
Brief.
Yeah, well, I read it in Judge Roach's opinion. That's why I didn't go.
That the prosecutor was under the belief that he had to, that anything he, that.
So I assume that was argued.
Yeah, the motion judge clearly did not feel that that was a reasonable explanation, or she would not have found that the prosecutor acted recklessly in either failing to review it, failing to assess its prejudicial impact, and then giving it to a witness who was completely unfamiliar with it.
Right. Let me ask if there are any further questions from the panel. Thank you, counsel.
Thank you very much.
Mr. McLean.
Good morning, Your Honor. May it please the court, Ian McLean on behalf of the Commonwealth, along with the trial prosecutor from this case, Assistant District Attorney David Bradley, who's listening to the live stream.
Before we get it, can I ask you about the argument that they were plotting outside of Rosario's? Is that pure speculation?
Of course you can, Your Honor, but before I respond substantively, I'd just like to address that the family of the victim are also watching on live stream, and particularly the mother of the deceased victim, Christopher Austin. His mother, Grace Richardson, is watching. Now, turning to the closing argument, Your Honor, as you requested, yes, I'd say it's a fair inference from the evidence that was presented to argue how you can interpret that evidence as to what the defendant's intent was, what was going through his mind. Intent is almost always established through circumstantial evidence. And other evidence. It's very, very rare that we have a direct admission from the defendant, I intended to do behavior X. So here what happened is the prosecutor was marshaling the evidence, and what he had was a video that showed the defendant's actions. From those actions, he was pointing out, look at what he did here. I think you should infer he was thinking this. Look at what he did here. I think you should infer he's thinking this. And those things being, first, when he sees the victim exit the store and he is across the street, he attempts to duck out of view. Second, after he allows the victim to walk down Ashmont Street a ways, he crosses the street over to the store and looks in the store through the clear glass window. What the prosecutor was asking the jury to infer from that is he was confirming that the victim was in fact alone, that there wouldn't be anybody else coming out of the store after him. And respectfully, Your Honor, those are fair inferences for the prosecutor to ask the jury to make from that video evidence that was in front of them. Then further support for why you can draw those inferences would be what happens next. The defendant returns to the blue Honda Accord, speaks with the driver of the blue Honda Accord, Keith Cousins, then they drive off down Ashmont Street. If they were only going to engage the victim in a conversation, there would have been no reason for them to stage the getaway car. They would have continued driving down Ashmont Street, caught up with the victim, parked the car, got out and spoken to him. Instead, they took the first left off of Ashmont Street and then parked the getaway car somewhere up there, which we know from the fact that the defendant was then seen running down Waldorf Street back onto Ashmont Street where the victim was walking. So they staged the getaway car at a place that would be 2 corners away from where the event was going to happen, so that one witness wouldn't see the shooting and the getaway car at the same time. Take those facts together, and now it looks like something that was planned from back when they first saw the victim exit Rosario's marketplace. So respectfully, I think those are appropriate inferences for the prosecutor to ask the jury to draw from the evidence in the case.
Can you address the grand jury issue in Judge Roach's findings? Do you concede it was a mistake to put the DOC records in totality in?
The totality of the records, yes, Your Honor. And I would start by saying, well, Judge Roach didn't make clear factual findings. She did acknowledge at addendum page 76, which is page 17 of her written memorandum and order. She did acknowledge it was a legitimate area of investigation. So her additional factual finding about how the records themselves were then handled, saying that it was reckless, we'd say that was a factual finding. But looking to establish a connection between these two defendants, specifically why the getaway driver, Keith Cousins, would be willing to act in a joint. Go ahead, Your Honor.
But you know, we don't need records when the person's 6 years old, right? I mean, and we don't need D reports. I mean, so what about this explanation that relies on Code A thinking, if I don't put these records in, it's going to be an abusive grand jury process? My memory of the case law is that you abuse grand jury process when you use that, when you use the grand jury to get trial records that you wouldn't otherwise be able to get under Rule 17. So is this something that was excusable by the prosecutor, or is this completely wrong, or where are we on that?
So, Your Honor, I'd say yes, it can be an abuse of grand jury process to use it as an investigative tool for trial. That's clear. Also, to like bring in a witness and talk to them outside of grand jury. So from that, we interpret that every time we use the authority of the grand jury, we have to put the information we obtain before the grand jury. So that's our guiding principle. Then how do you apply that in this particular situation where it was a legitimate area of inquiry in the right time span? I mean, we concede, Your Honor, that it was inappropriate to ask for time span when there was no possibility that they could have been housed together because one was a minor. Concede that was wrong. That was that we asked for too much. So if we get too much information, the question becomes,
it can't be that you blindly put records in front of a grand jury that are going to overly prejudice the grand jury against the defendant, right?
We agree, Your Honor. Yes, Your Honor, we agree with that. And that's where the error was here. Well, the first error was in seeking records beyond when they could have possibly been housed together. Then the second error was in not evaluating them before putting them in front of the grand jury. So then the question becomes, if you have information that doesn't provide any relevance to your investigation, what do you do with those documents? You can't simply not tell the grand jury about them. So we think the best practice in that situation, Your Honor, is to put it on the record, and so that there is going to be a transcript of it so that everyone will know, and there could be an Odell challenge subsequently. But to say something along the lines of, you know, grand jury, we've subpoenaed a bunch of records under your authority using subpoenas. We've evaluated them all. We don't believe there is relevant information in them, so we're not going to produce them to you. So now there's a record of it. So the defense would know that this information was subpoenaed, and they would receive it in discovery, and they can evaluate how they feel about that. Now, if you have a bunch of records and say 2 pages out of 100 are relevant, now the question becomes, how do you get those 2 pages in? You could, if it was a different proportion, you could simply redact out bad information. If it's not, redacting isn't going to work, then I think best practices would be basically what we just said, to tell the grand jury, we subpoenaed records, we received about 100 pages, only these 2 pages contain relevant information. Here are these 2 pages. Then there would still be a full record so that an Odell challenge could be raised, and the defense would receive those other 98 pages in discovery, so they would have access to the material that didn't go to the grand jury. That's probably what should have happened here, Your Honor. Just a very tiny portion of records that showed the brief overlap between the 2 defendants at Sousa should have gone into the jury, and with an explanation as to other records existed but were not relevant to the case, and so we're not coming into the grand jury. That would have probably been best practices, also combined with a limiting instruction. But here what the prosecutor did was put it all in, but did provide a limiting instruction. And
well, kind of. It wasn't much of a limited instruction, and it was preceded by, here you go, have at it, or something like that.
Well, yes, Your Honor, and I can come back to here you go, have at it in a moment, but the actual words of the way the limiting instruction ended were this. It's brief, and if you let me get through them, it'll help inform the court here. All right, again, let me just rephrase that a little bit better, but basically, do not use the fact that they have been arrested before, done time in deliberations when you determine whether or not they committed this crime. That's a clear instruction in plain English that the jurors would have been capable of following, and we presume that they follow those instructions. Now, the comment that you referred to, the sort of flippant sort of comment, when you place that in context of what had just happened in the grand jury with the prior witness, a video thumb drive had just come in, and there was conversation back and forth about the voluminous amount of information that the grand jury was going to have to evaluate here. So it was sort of a callback, both it responded to the call of the question from the grand juror himself and was a callback to what had just happened a few pages before. If you read it in isolation, it sounds like maybe it's even nefarious possibly. But when you read it in the context of everything that happened that day in the grand jury, it's not at all nefarious. So what this boils down to on the grand jury issue is a valid limiting instruction explaining to them that they could not consider the fact that they had done time before for the purposes of this indictment. So if we look at the three components of the test here that are all the defendant's burden.
There are also other problems with the grand jury presentation involving other witnesses, correct?
I would disagree with
that are raised.
Not on appeal, Your Honor. There were other challenges that were raised in the motion to dismiss below, but none of which were raised in appeal. My understanding of the appellate issue is limited simply to the Department of Corrections records that were introduced. So the three prongs: knowingly or acted with reckless disregard, presented false or deceptive evidence. So reckless, yes, as Judge Roach found, but it's not false, nor is it deceptive. The question here is one of prior bad acts, really. So, I mean, I'd point the court, as a result, I'd point the court both to Matthews and Rakes, where curative instructions were enough to address the prejudicial impact of prior bad act evidence. And in Rakes, it was incredibly powerful prior bad act evidence. In Rakes, it was the defendant's own statements that he kills people for money, that he should remember the 5 Ps when you kill somebody. Proper planning prevents poor performance. And also a mention of the defendant's invocation of his right to counsel. And that was all found to be cured by a curative instruction, a limiting instruction provided by the assistant district attorney that was in the grand jury there. So then the second prong of the test here, was this evidence presented for the purpose of obtaining an indictment? Not really. This evidence was about establishing ties between the two actors. This evidence was really geared at the co-defendant to explain why he would be willing to act in a joint venture with the defendant. This had nothing to do with establishing the defendant as the shooter.
So you're saying that the findings were clearly erroneous then?
No, Your Honor. I'm saying that.
Well, that's what Judge Roach said, that the defendant satisfied parts 1 and 2 of Mayfield, but not 3.
She did, Your Honor. Yes, but I'd say that these are really questions that are mixed questions of facts and conclusions of law. Like, for example, in the first question, it's knowingly.
But this goes to the purpose for which it was obtained, and the judge down below was trying to ascertain essentially the state of mind of the prosecutor. Why was this done? So you have to argue to us, right, that it's clearly erroneous.
Well, it's fine, Your Honor. I interpret it as a conclusion of law, but if you say it's a factual finding, then I would say it's a clearly erroneous factual finding based on the record below. But then move to the third prong, and that's really where we decide these questions. Did this evidence probably influence a grand jury's decision to indict? So the defendant has to establish, without this evidence, a grand jury probably would not have indicted. And as Justice Cipher pointed out during my sister's argument, we have the benefit of the trial here, and this defendant was convicted. Now we're talking about essentially the same evidence that came in at the grand jury level as came in at the trial level. So
that's the federal standard. The federal standard says that basically guilty convictions wipe away grand jury mistakes. We don't have that law, right?
Yes. Well, Your Honor, I think it has been applied in McCarthy situations, but I don't know that it's necessarily always applied in Odell situations.
Right, not Odell Mayfield. When we have prosecutorial misconduct, essentially, in both those instances, we don't say, well, you got a conviction, no harm, no foul. That's not our law, right?
Correct, Your Honor. But the third prong of the applicable test here is that the evidence probably influenced the grand jury's decision to indict. So,
right, so we have to look at the strength of the evidence that was presented and the amount of prejudice occasioned by the use of the grand jury technique, correct?
Exactly, Your Honor. Exactly, Your Honor. And here, I'm simply making an analogy to the fact that the evidence that came in at the grand jury level was essentially the same evidence that came in at the trial level. All of those crucial witnesses that we're talking about here, Mr. Harper being the most important, came in and testified, and his testimony was consistent with what he testified to at trial. The Rosario's video came in. The video of the defendant being interviewed at the Boston Police Department showing his chipped tooth. The testimony from the family members that identified him in the Rosario's video.
Also, that prong 3 under Mayfeld is not a sufficiency of the evidence question, right? So at the least, the judge got that wrong. Isn't that right?
Yes, Your Honor, it's not really a sufficiency of the evidence argument, but what the question is, if there was sufficient evidence for the grand jury to indict this person, then it's much less likely that this had any influence.
Do these 100 pages of prior bad acts influence that decision, or what is the standard?
I'm sorry, Your Honor, you cut out at the end.
Well, the third prong isn't a sufficiency question. So the question under the third prong, it seems to me, is whether these 100 pages of unreviewed documents showing the defendant to be a bad guy influence the grand jury in coming to the probable cause decision that they had to.
Yes, Your Honor. Did the wrongfully admitted evidence probably influence a jury's decision to indict? So yes, you're right. Technically, it's not a sufficiency of the evidence analysis, but if you have to evaluate all of the evidence that did come in to see if this would have, I don't know, tipped the scales to achieve the level of probable cause. And probable cause is not that high of a standard here. There was more than adequate evidence that was introduced to justify indicting this defendant as having been the shooter himself.
Can you get to that though? I'm sorry, unless Justice Wendland has any further questions on this.
No, I think your follow-up is exactly where I was going to go. So go ahead. Yeah.
Okay, so can you read my mind? Can you tell us the best case you have, or the closest case to an inference that this was the shooter, based upon a witness seeing the front end and then the back end, but not the shooting of this incident?
Well, Your Honor, I don't think there is a case that is perfectly factually analogous, but what I have is a witness that placed him passing him at about 92 Ashmont, running right up to and engaging in conversation with the defendant, and that witness noting that he saw no one else on the street in the vicinity, nor did he hear or see a car drive by. And then just a matter of a few seconds later, the defendant is shot a single time in the face with stippling on his face, meaning he was shot from close range. Then again, Mr. Harper exiting his residence and not seeing anyone else on the street. So we have no one else around and a wound that was inflicted from close range. So yes, we don't have an eyewitness that observed the murder occur, but we have basically the next best thing. No one else was around other than the defendant, and the wound was inflicted from close range. This is not a second shooter on a grassy knoll with a long range rifle.
What's the time frame we have between, I know it's Rosario's to the shooting is 10 minutes, but what's the time frame between the time that the person who was working out sees them, goes up to his apartment, and then hears the gunshot? Like how much time elapses before the shooting from the last sighting by this, I think it's Mr. Harper, right?
Yes, sir, it is Mr. Harper. We don't have an exact amount of time. What we have is the amount of time it took him to walk up the stairs into his house, enter his door, turn off his security alarm, and then he hears the shot. Then he turns around and looks out the window and then comes back out. So we don't know exactly how many seconds that is, just an estimate, but seconds.
Yeah, was he asked at trial to estimate how much time?
He may have been, Your Honor, and I will go back and look at his testimony. And if there is a specific amount of time, I'll send a 16L letter before close of business today that gives you the reference to the exact amount of time that he testified to. But my recollection was simply that he was a little more vague and said just a matter of a few seconds.
Okay.
And a few meaning 20 seconds, 30 seconds in that area, but I'll confirm and send a 16L. Then in addition to Mr. Harper, we have the other witness who was across the street, basically at 90 something on Ashmont Street. He hears the shot, turns around, he's sitting on his couch in the living room, turns around, looks outside the window, also sees only one person fleeing, and fleeing the exact same flight path that the defendant was fleeing. So that's the defendant that he saw. So now we have a second witness who didn't see anyone else or hear or see any cars drive around. So now we have two witnesses that place the defendant as the only person with the victim at the time the shooting occurred, and the shooting was inflicted from close range. So the inference that I'm asking you to draw is that the defendant was the shooter. That is a reasonable and possible inference from those facts. It doesn't have to be necessary or inescapable, just reasonable and possible. And that is absolutely reasonable and possible. Also add in the fact that the defendant, as I discussed previously, basically staged the getaway car. If this wasn't going to be a murder, Why, when you're driving down Ashmont Street from Rosario's, why don't you just stay on Ashmont Street and go talk to the defendant? Why do you take the first left off of Ashmont, stage the car, and then run down Waldorf Street to rejoin Ashmont to catch up to the victim? This was planned in advance that they were going to do this. And that, again, is a reasonable inference that can be drawn from that evidence. So there was sufficient evidence to establish that the defendant acted with, was the shooter, acted with intent to kill, and acted with deliberate premeditation. As to the sufficiency of evidence for the firearm possession, he was arrested that morning in bed, partially clothed with the female guest. The gun was found tucked on the floor in the closet right inside the door.
We have plenty of cases on constructive possession. We'll see how this lines up. I'm more interested in, at this point, the identification instruction. Was it a mistake for the judge to term it identification as opposed to description?
No, Your Honor, because the first at the top of the instruction, which is page volume 11, 108 to 109, the way he tailored the first sentence of the instruction made it clear what we were talking about. He changed it from where a witness has identified the defendant to where a witness has provided a description which may identify the defendant. That's the way he started this piece of instruction. Then over the course of the next about a page of transcript, he did use the word identify a few times, but each time it's a callback to that initial portion of the instruction. So there's no abuse of discretion there. And yes, Your Honor, you did point out during my sister's argument that the difficulty that judges experience here is this model instruction requires a significant amount of tailoring when we have a description of a person as opposed to an identification. And here the judge did a good job of striking out things that were not applicable: cross-racial ID, suggestive conduct, express certainty, photo array, show up, multiple viewings, failure to ID, and including only the things that were relevant or pertinent here. Your Honor, if I may, I'd like to briefly address the reasonable doubt portion of the instruction as well. Yes, he did excise that last portion of the model instruction, but the reasonable doubt component was included in his instructions. You've got to look at the instructions as a totality under Batchelder. So I would point out that he provided an initial charge prior to the parties' closing arguments, and he gave the reasonable doubt charge as part of that, volume 11, pages 35 and 37. Then in his final charge, he reiterated reasonable doubt before the instruction on eyewitness identification. That's at page 101. And then following the eyewitness identification instruction, and that's at page 113. That's when he also gave the moral certainty provision. That's 113 to 114. So here, even if the reasonable doubt sentence was not included specifically in this instruction, it was addressed multiple times for this jury. So they were well aware of the applicable standard here. And then I'd also point the court to the Johnson case where we don't have an actual identification of a person. That specific reasonable doubt provision at the end isn't needed because it's captured in the regular standard reasonable doubt instruction. And the trial judge here was aware of that, as he referenced on volume 11, page 9. And that's why he excised it from his instruction that he tailored specifically to the facts of this case.
Any further questions? Okay, go on, Mr. McQueen.
I was just going to say, Your Honor, I see that I'm out of time. If there are any other questions from the court, I'd be happy to address them. Otherwise,